Good afternoon, everyone. And again, thank you for attending our webinar today. If you have attended our webinars in the past, welcome back. And for all of our first timers, welcome. Those of you who I have not had the pleasure of meeting yet, my name is Robert Tauber, and I am the Regional Vice President of Operations for Southern Florida. On behalf of Vesta Property Services, I would like to thank you all for taking the time to join us today for this presentation. Today's discussion will be centered around screening applicants for sales and leases in condominium and homeowners associations. Partnering with Vesta for this webinar, our presenter today is Andrew Black from the law office of Kaye Bender Rembaum. Kaye Bender Rembaum is a full-service law firm representing community associations throughout the state of Florida, and Andrew is a board-certified specialist in condominium and plan development law. It is now my pleasure to turn the microphone over to Andrew and begin the webinar.
Great, thank you. I want to thank all of you that took the time out of your day. You could be doing anything in the world right now, but you chose to spend an hour or so with us. So on behalf of our firm, we genuinely appreciate that. And I want to thank Robert and his team as well for hosting this. For those of you who have seen me present in the past, I like to kind of keep it in an informal way. You all do have a good outline, and it's on the screen as well. But I like to share some anecdotal stories. Certainly, our firm and our clients deal with the screening process each day, and there's lots of questions that arise. And hopefully we will address all of the questions that you all have. It works the best if you do have a question to use the Q&A. Just type your question there. We'll definitely take time at the end. Usually I go through my spiel about half an hour or so, and I'll definitely leave lots of times for questions. I like to start off every course that I teach from a broad view. And if you're on your board right now, or you're thinking about running for your board, I think it's important to understand that as a member of your board, your association, whether it's a condominium, an HOA, you are a not-for-profit corporation, and you have to run. There's activities that need to happen each day. And as a board member, you have what's called a fiduciary duty to your owners. A fiduciary, it's just a fancy word. It means you're in a position of trust. So every action that you take, every decision you as a board member make must be for the benefit of the entire community. So not any personal agendas or anything like that. It's what's good for the entire community. That's what being a fiduciary is. And when you hear such phrases as a breach of the fiduciary duty, that's what they're talking about. And courts historically, when they're faced with a breach of fiduciary duty claim, courts will analyze whether they exercise what's called reasonable business judgment, the business judgment rule. And all that business judgment rule means is, it means what would an ordinarily prudent member of the board, what would he or she have done if presented with the same facts? And if you as a member of your board would have acted in the same way that an ordinarily prudent individual would have acted, you would have used your reasonable judgment. You would have complied with what your fiduciary obligation is. So I like to just start off every course getting that mindset, at the forefront of your mind. To the topic at hand, the screening process. And I like to start off with, I always share the story of when my wife and I were searching to buy our first home. Maybe I've been working in this field for so long, I thought, you know what? Maybe a condominium isn't for me. I tried to look for, a single family home without any HOA in South Florida. That's very tough. So we settled on a beautiful townhome community. It's an HOA governed under Chapter 720 of the Florida statutes. We had a closing date set, and anyone who's bought a home knows there's always some fire burning at the last minute. The bank forgot to do this. The title company needs this. It's always a scramble. So we get the closing date. Everything's established. We're super excited. Closing scheduled for a Friday. On Wednesday, late afternoon, our real estate agent calls me, and I thought, that's strange. She's been dealing with my wife during this whole process. That must mean that something's wrong, you know? So I call my real estate agent back, and she says, we have sort of a problem. The association via the property manager just contacted me and said that you and your wife haven't been screened by the HOA yet, and you need to be screened before your sale can go through. And I thought, that's odd. I actually read, and it would be foolish, especially for me, if I didn't do this, right? But I read the governing documents for my HOA, or soon to be HOA, and there was nowhere in the governing documents at all that gave the board the authority to approve a buyer or to approve a sale. There was a small paragraph that said a copy of the sales contract has to be submitted, but that obviously is separate from actually requiring an application and a approval. So I thought, all right, this isn't a adverse party. You know, this is my community. I want to, buy in. So I want to be friendly and nice. And I know that the property manager often is simply following instructions from what the board is saying. So I wrote a nice email to the property manager, and I said, my wife and I are very excited to buy our home in this HOA. I understand that you're requiring an application and a approval process. However, I read line by line the entire set of what the governing documents are, and there is no authority for the board to review and approve this sale. So I don't have a problem with, you doing a background check on me if you want to, but we have a closing date scheduled for Friday. So if you somehow interfere with that, there might be a serious problem. To the property manager's credit, he called me back within the hour and said, in his 20 plus years, I'm the first buyer that's actually read the documents line by line, saw that there was no sale approval process, and essentially called them out on it. Now, I don't know if that's true if I was the first person in 20 years, but my main initial point is the ability of your association to review and approve a buyer, a tenant, an occupant, a guest occupant, and I'll talk about that soon. The ability to review and approve those individuals must be set forth in the governing documents for your community. The declaration of condominium, if you're a condo, or the declaration of covenants and restrictions if you're an HOA, okay? It's not enough if the declaration is silent on the ability to review and approve a buyer or someone wants to rent. If the declaration is silent, in our opinion, the board does not have the authority on its own to adopt a rule requiring that approval. So your homework, if you're on your board or if you're a manager or you're someone who's thinking about running for your board is to confirm that your declaration actually has approval authority. That's step one. I can't tell you how many clients we've dealt with where they'll say, Andrew, this person wasn't approved. I review what their documents say and there's no approval rights, okay? If you have approval rights, you need to confirm the scope of those approval rights, all right? So you need to evaluate what that authority is. How far does it go? Is it just a sale and someone who wants to rent is not included? I've seen that where you only have sale approval rights. I've seen where you have sale approval rights and lease approval rights. However, I've seen where it doesn't extend to all transfers of ownership, because you all may know a sale is not the only method someone can convey ownership in real property. There could be a quit claim deed, a gift. Let's say your best friend from college hits the lottery, comes into millions of dollars, and they want to gift you ownership of a home. And to accomplish that transfer of title via a gift, they use a quit claim deed, which just basically says whatever interest in this property I have, I'm transferring it to John Doe, okay? If your documents do not expand that approval authority to all transfers, not just sales, if the question is raised, do we have a board have the authority to approve that gift from my college friend? The answer is no. It only says sale, and a gift is not a sale. So you want to be aware of how broad your approval authority is. Also, we get asked this a lot, where your governing documents do give the board the ability to approve someone who wants to rent. So tenants and lease agreements need to be approved in advance. So we get a fact pattern oftentimes where John Doe, who's the owner, moves someone in. The board reaches out to John Doe, says, John, you're renting your unit without board approval. John comes back and says, oh my goodness, I'm so sorry. I want to be a good owner. I respect the association rules. However, I'm not renting at all. This is my friend. This is my, brother's friend. And there's no lease agreement. There's no rent monies being exchanged. So there is no tenant. And we get asked a lot, well, what do we do? And I always say, well, unless you have a smoking gun proving that this person is in fact a tenant under a lease agreement, unless you have a smoking gun, which is obviously very hard, someone who's a guest of an owner staying in a unit, that guest occupancy is separate and distinct from a tenant renting a unit under a lease agreement. So you need to see how wide your authority is in your governing documents to address guest occupancy, okay? So that's the main point I want to hammer home before we get into some further details, which is make sure your governing documents actually have approval authority. And if your documents do, the scope of it. Is it sales, all transfers, tenants, and guest occupants, okay? Now, the actual application process is crucial. There should be a timeline that you're aware of. So if your governing documents have approval authority, almost always there's an application process in the documents as well. And there'll be a time frame for when the board must render its approval or disapproval decision. I've seen a range. I've seen documents that give boards 30 days is fairly common. I've seen 45, I've seen 20, I've even seen 10 days. And if you think about it, 10 days is not a whole lot of time for a board, or if the board has approved a sale or lease committee to handle these applications, 10 days is not a whole lot of time. No matter what your time frame is, I think it would be a good idea for the board to adopt a rule to supplement what your governing documents say. And that board policy could say something along the lines of that time frame does not begin until the board has received completed application. So the application must be filled out. You get your background report from the third-party background company that your community uses. You have everything in. That's when the time frame starts. Now, I have members of my family who have been selling homes for years. Real estate agents are wonderful people, and this is not a comment on the profession as a whole. But I think we all know, usually, if you're a good real estate agent, you want that transaction to close when? An hour ago, right? There's always a sense of urgency when managers are contacted or board members are contacted by real estate agents asking for the status. If your documents provide you with 30 days, you have 30 days. That does not mean you should sit on your hands for 29 just to prove a point. You should reasonably respond, of course, and you need to operate in good faith. But if the documents say 30 days, do not let someone pressure you into making an immediate decision. Because once that decision is made in writing, it is very hard to rescind that, right? If you approve somebody, they, under the law, there's a strong argument that that buyer can reasonably rely on the approval that they received. And based on that reasonable reliance, that buyer may have done certain things that would incur damages. They might have moved from out of state. There might be other costs that they've incurred. So be aware of what that timeline is and do not let someone pressure you, right? Don't let someone pressure you into making a rash decision, okay? Part of the application, I want to walk you through what the process is, right? If your documents, remember the underlying authority to approve this transaction, your declaration must have it, right? So if you have the approval authority, we get asked all of the time, the fees that your association can charge. Under 718, which is the Chapter 718 of the Florida statutes, which is the Condominium Act, it governs condominiums. 718 was recently changed to say that it's called a transfer fee. People use lots of different words. They call it an application fee, a screening fee, but it's a transfer fee. The law was changed. It's $150 is the maximum fee, okay? And there's language in the law that could be increased by law to, with the consumer price index as the years go on. But right now, in 2021, if you're a condominium association, the maximum transfer fee you can charge is $150 per applicant, okay? Husband, wife, and parent dependent child are considered one applicant. Now, the authority to charge a transfer fee, your declaration, your governing documents must include that authority. I've seen some documents where they have sale or lease approval authority, but whoever drafted it basically screwed up, in my view, and didn't also include the ability to charge that transfer fee, okay? So be aware of that. For condominiums under Chapter 718, the statute also allows a board to charge a refundable security deposit if someone wants to rent. So you can require a tenant to submit that refundable security deposit. That security deposit, it's held by the association. It's held to make a claim for any damage that the tenant may cause during the time period that he or she is renting a property within your community, okay? It's refundable, meaning if there's no damage caused by that tenant and there's no basis for an association to make a claim upon that security deposit, you are required by law as an association to return that security deposit to the person that turned it in. We included in our outline a snippet of an article from about 5 years ago where lots of associations were charging lots of non-refundable fees that were outside of what the transfer fee was. They were charging non-refundable elevator fees, move in, move out fees, all sorts of additional fees in excess of what the statute allows. And remember, $150 max if you're a condominium. For HOAs, 720 of the Florida statutes is silent on the maximum amount of what the transfer fee should be. Your governing documents for the HOA should, in our view, should reference the ability to charge that type of non-refundable transfer fee. But there is no cap. It obviously needs to be a reasonable fee. We have lots of HOAs that just follow what the condo statute is and charge the $150 max. The application itself, there's lots of forms out there. There's no one size fits all, but the purpose of the application is to gather information, right? Names, the cars that they're going to bring in, whether they have any animals, contact information. What I always suggest as a practical thing, because lots of boards ask us, can we email notice of meetings to the owners? Can we use email as the exclusive way? And I always say the statute allows you to, if you have the signed consent from that owner to use their email as the exclusive means of sending them official association things. So perhaps just a good practical idea is part of the application materials themselves. You have an email consent block where John Doe's buying a home. John Doe gives his email address and specifically consents to the HOA using that email address as the sole means of sending out official association things. Sometimes management companies and boards like that because you save some costs on to mail. I want to touch base on the interview process because I've seen lots of sort of wacky things arise from it. Lots of times, part of the application will be a personal interview. Nowadays, they're done via Zoom as well, right? In our view, our opinion is the face-to-face interview, whether in person or over Zoom or some other remote way, in our opinion, that face-to-face interview should only be conducted once you have the entire application, you have the background check, and everything looks good, and you're ready to approve that applicant. That interview then essentially just becomes a meet and greet. Welcome to the community. Here's the current rules on trash cans and whatever, where you can address housekeeping matters. Our opinion is that face-to-face interview should not be done earlier on in the process, because what will happen, and we've seen it happen, is you do the interview early, you then get the background report back, or something else emerges, which may be used by the board as what's called good cause, and I will talk about that soon, good cause to deny them. And it might be a valid and bona fide good cause reason to reject that applicant. You send out the written rejection letter, and the applicant claims what? They could claim discrimination, whether it's based on race, national origin, gender, age, if you're not a housing for older person community. And we've seen that happen. And so our practical advice is, if you think about it, it's a lot harder to claim discrimination if the board or who that interview committee is has not met the applicant face to face. Okay. I can't say they can't still make a discrimination claim, but it's certainly is a stronger argument for the association to say, not only would we never engage in any discriminatory conduct, we didn't even meet the applicant face to face. So that's just some good ideas there. Okay. Now, I talked about a discrimination claim. What does that mean? Okay. You all have some idea, I'm sure, but discrimination means there are federal and state, Florida's got its own fair housing statute, but there's federal and state fair housing laws that essentially state housing discrimination is prohibited. And housing discrimination means you cannot turn someone down based on a constitutionally protected class of individual. So based on race, religion, national origin, gender, marital status, those types of constitutionally protected classes, we all know you can't engage in housing discrimination. So it's just very important to be aware of that. And I always state, if our board clients are thinking about rejecting an applicant and you have any uncertainty at all, whether you have what's called a good cause basis to reject them, our strong opinion is before you issue that written disapproval, get with our firm, right? Or get with whatever association counsel you all use. And now is a very good point just to highlight. And usually I do this before I start, but I think it's important. And this is my attorney disclaimer, right? What we're going over today, this is a general education course, right? This should not be construed, obviously, as direct legal advice for your board. Why is that? There's two primary reasons. The first is legal issues are very fact specific, and any attorney who's worth his or her salt needs to review what those particular facts are, because there's lots of extenuating things that could be important before an attorney can give his or her, give his or her view on what should be done. And the second part of that is the second reason why is, of course, the Florida bar is strict. There needs to be an attorney-client relationship established, right? So this is just general information. So please don't go back to your fellow members of your board and say, John, guess what? We met with an attorney and we got advice. We have the authority to do X, Y, or Z. That wouldn't be an appropriate comment. So if you do have a particular community fact pattern, get with your association counsel on that. But I just wanted to take a mention on that. This slide here is just very quickly discussing the different types of transactions there are. And again, it's important to understand and confirm what your declaration actually says, what the scope of that authority is. Okay. The notice. So now we've gone through the process. You've confirmed what your documents say, how wide your authority is, right? We've gone through the application process, a transfer fee, a security deposit, the interview, making sure, of course, you don't engage in any housing discrimination during this process. And the board's ready to render its decision. It needs to be in writing, obviously. And I want to point out, in Miami-Dade and Broward County only, there's actually a county ordinance that requires the association to render its decision within 45 days. Now, if you're in Broward or Dade and your documents only give you 30 days, you want to follow the 30 days, okay? But this ordinance is important for Broward and Dade because this ordinance says that notice to the applicant must give a specific reason for the denial. It doesn't tell you how specific you need to be, but there needs to be a specific reason. For instance, perhaps negative financial history. That's specific because you're telling them it's a negative financial matter, but you're not going so far to say, well, you filed for Chapter 7 bankruptcy in 2020, right? You're not going that far. But just be aware of that. If you do not have a standard disapproval letter that your community uses, whether you're in Broward or Dade or not, I think it's certainly a prudent idea to get with your association counsel to make sure that your denial letters are standard and do not inadvertently run afoul of any fair housing laws. And there's a brief mention here of any other law as far as what you disclose to the applicant. Because remember, under the law, the background report, that criminal history, that financial history, those items are private and they're confidential, meaning they're not part of the official records that the other owners get to inspect. So if I'm an owner, I'm John Doe, I don't get to see Sue Smith's criminal history. That must be kept private. Okay. So we're at the point, as I said, where the board is thinking about perhaps rejecting an applicant. And we've established already it can never be based on a discriminatory reason, right? Based on a constitutionally protected class. So what are good cause factors? Again, there is no case law in Florida that has an easy list that every condo attorney could say, here's the list that this judge said. Unfortunately, no such list exists. What our general advice is, and this is based on years and years of dealing with these things, there are a couple items that could potentially be good cause factors. Again, I'm not going to answer your specific question today. Can we deny someone because of this, right? You need to get with your association counsel on that. But I do want to give you some good cause factors that you should be aware of. And if you don't have these good cause factors in writing, the board should adopt them at a minimum as a board rule that you add to whatever application materials you use. We prefer, obviously, that the declaration is amended to clearly itemize these good cause factors. So that's what our preference is, to amend the governing documents. But at a minimum, the board should have a rule. Okay, some potential good cause factors. One of them is material misrepresentation on the application. The applicant lied. The applicant, where there's employment history, said they were the chief financial officer of a bank for a 10-year time frame. Your background company does the employment verification. That bank comes back and says, that's not accurate. They worked as a front desk clerk for a month. To me, that's likely a material misrepresentation. So the applicant lied. That could be a basis for rejecting for good cause. Now, if someone leaves something blank, that is not a material misrepresentation. If someone leaves something blank, you should not issue a disapproval. You should inform the applicant, you left some items blank. We are unable to process this application until it's completed and until such time no approval will be forthcoming. Okay? So they lied. That's one. Another potential good cause factor is the application on its face demonstrates an existing violation of what your governing documents say. And that's a mouthful. That simply means, let's say your declaration clearly prohibits commercial trucks. And there's a definition of what that means, right? Visible tools of the trade. You might have certain size restrictions. but you have a commercial truck restriction. The application that's turned in for that, let's say someone wants to rent and the tenant lists his vehicle as a commercial truck, the application on its face, that truck is demonstrating that that applicant will violate what your existing documents are. So that, in our view, would be another good cause factor. So the applicant lied, a material misrepresentation, or the application on its face shows an existing violation. The third one, and this is a common one, and the next two I would say are the most common ones. The next one is criminal history. Now, HUD, and it's in the slide here, HUD is the federal agency that handles discrimination complaints. And HUD, every so often, will publish their views on how discrimination policy should work. HUD came out with they published their guidance on criminal history and associations. And what the HUD guidance essentially states, and this is the guidance we in turn have provided our clients, is that the criminal history must be a felony conviction or a guilty plea to a felony crime. Okay? It cannot just be a misdemeanor offense, and it cannot just be a charge of a felony crime, because in this country, we're what? We're presumed innocent. Okay? So it needs to be a felony conviction or a guilty plea to a felony crime. So you need to know what the disposition, that's the fancy word, the disposition of that criminal case. Most of the time, the background report that you get will show that. But in our view, if you denied someone based on a misdemeanor issue or on a just a charge, that could expose the association to a potential discrimination claim. Okay. We get the $1 million question. How far back can we go? I wish I had an easy pocket answer to say, this case in Florida has said you can go back this number of years. There's no such Florida case out there. So unfortunately, the board has to review how long ago the felony conviction was. Okay. If it was 25 years ago, and that applicant since that time has been an outstanding member of this world, and everything else in the background report looks great, in my mind, the board absolutely has the authority to approve that individual. And there could even be a challenge if they disapprove them based on something that happened so long ago. I've heard various managers and boards say, if it's a felony crime involving violence, we're going to go back 10 years or 7 years. I've heard all various sort of rules of thumb. My suggestion is you don't necessarily want to box yourself in with a hard and fast time frame. Okay. You want the board to have some modicum of flexibility to evaluate what I call the totality of the application. Okay. So you want to just be aware of that. But the big takeaway today is it's got to be a felony guilty plea or a conviction of a felony crime. All right. That's criminal history as a potential good cause factor. Another one, which is a huge one, is financial history. Okay. Now, in our view, financial history absolutely could be a potential good cause factor to deny an applicant. In our opinion, it's most appropriate for someone that wants to buy as an owner. And the reason is quite simple. That owner has the direct relationship to the association. They have to pay their assessments on time. So the financial history of an owner, in our view, is likely more important than the financial history of someone who wants to rent. As I say that, I know there might be people out there that says, well, wait a second. If the owner stops paying us assessments, I know that we're able to collect rent directly from that tenant of that delinquent owner. And you're right about that. So is there some relationship between the financial history of the tenant? There's some, but in my view, it's not as strong as the financial history of the owner. The financial history, certainly, if that applicant has a record of bankruptcy filings or a record of foreclosure actions, whether it's a bank foreclosure or even another community, if there's a record of bankruptcy or foreclosures, that certainly could be good cause to deny an applicant. We get asked all the time, what about a minimum credit score? Certainly, that could be a basis to turn someone down. We prefer that the board policy is crafted in such a way that a minimum credit score is one factor that the board can utilize when they review, as I said, the totality of the applicant. And the reason I say this is I've seen fact patterns where a board has adopted a minimum credit score, and I'm using this as an example. They've adopted a minimum credit score of 700. The applicant comes in at 698. It's an all cash purchase. Everything else checks out. Employment history is great. They've lived in another community for 15 years, no problems at all. For all intents and purposes, they look like a wonderful candidate to be an owner. With the only issue, they're 2 points low. In my mind, the board should retain some modicum of flexibility to approve that applicant. So minimum credit score, I've even seen minimum income requirements. I've seen debt to income percentages. I've seen all sorts of things. Those types of financial standards can be used as potential good cause to turn someone down. But again, whether it's minimum credit score, minimum income, or something else, that should be one factor. I don't love the concept of as a bright and hard fast line rule. Okay. Now, if you do turn someone down, lots of times the applicant will say, I'm going to sue you. The good news is there's case law in Florida that says an applicant does not have what's called legal standing to file a lawsuit against the corporation, so the association, right? Now, that doesn't mean an applicant can't file a discrimination claim. It doesn't cost anything to file that, but they don't have, an applicant does not have legal standing to file a lawsuit against the condo or the HOA. Usually the lawsuit will come from the owner who's trying to sell, and there's potential for financial damage of that selling owner if, in fact, it's demonstrated that the board improperly denied someone. And the financial damage is as follows. The market's fairly great right now, but we know how the market goes up and down. So the potential financial damages is an owner. I'm John Doe. I'm an owner. I want to sell. The sales price is $400,000. The board rejects my buyer. The allegation is that it was an improper denial. I then am forced to put it on the market again, so I have costs involved with that. And then I'm only able to sell it for $380,000, $20,000 less than what the sales price was. In that case, I actually have actual damages of $20,000, and that owner could look to hold the board responsible. Because lots of times people claim they're going to sue, but there's no damage, right? In order to have a successful lawsuit, a lot of the times you need actual damage. In this case, there might be actual damage. So you want to be aware of that, okay? I would be remiss, and I know I've been blabbing on for a while, so I'm going to open it up to questions. I would be remiss if I didn't mention there's a concept in the law. It's called the right of first refusal. I'm sure you all have heard that. And in your documents where you have sale approval authority, I'm willing to bet that there's a right of first refusal language there. What that means is if the association denies for something other than good cause, and other than, of course, because you can never deny for a discriminatory reason, but if the association denies for something other than those issues, for instance, the board thinks that the sales price is too low based on what the fair market value rate is. If the board denies based on that fair market value price, then the board has to, what's called, exercise a right of first refusal. And they need to find a third party. It can be the association oftentimes. They need to find a third party who's willing to step into the shoes of that proposed buyer under that sales contract, okay? So we have had some clients over the years where they have identified perhaps a sale that is at a lower than fair market value price. They properly exercise their right of first refusal. They have the money, they're ready, willing, and able to, follow whatever the contract terms are. And we've seen it where the association actually buys that unit at that lower fair market value. The association becomes the owner, then they turn around and sell it to a third party for the fair market price, and that can certainly be advantageous to the association. Okay, I want to just point out, because I usually see questions. If you're a housing for older persons community, which means 55 and up, okay, that's when the occupancy of the homes or the units, you have at least 80% are occupied by someone that's 55 and up. Remember, it's occupancy, not ownership. The record owner of that home can be any age. It's who the occupants are. But certainly, if you're a housing for older persons community and the application comes in and the only occupant is under 55, you can absolutely deny based on that age. I sometimes joke that's the only discriminatory conduct that's allowed under the law is based on age when you're a housing for older persons community. With that being said, I have 148. I wanted to open it up to questions, and I'll take a look, and obviously Robert as well, if there's any questions as well, feel free to chime in. We get asked a question about the application itself. If it's an all cash purchase, what types of things can we require the buyer to turn in? Certainly, if you have a board adopted policy, you can ask for tax returns, sometimes bank account information. What I don't recommend boards doing is speculating on, where this money's from and something seems wrong. I get that a lot, that we have a lot of sort of amateur sleuths out there who want to launch an investigation into, where this buyer, how do they have this money? And I'm a little bit reluctant. I don't really think that's the association's role there. We got another question, which I think is a great question, is whether the board can assign the screening process to a committee. And the answer is yes. In my opinion, unless your documents have something that would prohibit it, you need to get with your association's counsel, but a majority of the board almost always has the committee appointment authority. And there's like a finding committee, an architectural committee, but oftentimes you can assign it to a committee, whether that's other members of the board, whether that's a staff person, whoever the board thinks is best suited to perform that task. A majority of the board can certainly assign that task. There should be minutes of the board meeting reflecting that a majority of the board approved that. Oh, pardon me. Okay. So we got a very particular question on the way the governing documents read regarding the right of first refusal. Again, almost all documents have the right of first refusal. However, if the board denies someone based on good cause, they don't have to exercise that right of first refusal, and it can be a straight denial. And there's a famous case in Florida, and let me explain the rationale behind that. If a board was forced to exercise a right of first refusal and find a buyer every time they turn someone down, even for good cause, you can imagine there would be lots of games being played. For instance, I'm an owner. I would find the worst person, the worst convicted criminal of all time, knowing, and then I would just tell them, say you're going to buy my home for $500,000, right? Knowing that the board's going to deny that convicted criminal. And then I would force the board to then find a buyer to buy it at that $500,000 inflated price. That would be a unreasonable and, quite frankly, an absurd result. So that's why, if there is good cause, the board can issue a straight denial. All right, these are great questions, and I really appreciate it. I have a very specific question on the scope of authority based on a provision, whether the provision of this community's documents includes all transfers or just a sale. I respectfully direct that person, you got to get with your association's counsel to review exactly what your documents say on there. Okay, we got a question that is saying, if the declaration is silent, can the board adopt a rule to allow for sale, transfer, or lease approval authority? In my view, and I attempted to highlight this at the start, in my view, no. Your declaration must contain the underlying approval authority. And if your declaration is silent on the underlying approval authority, under the law, the presumption is that there is no sale approval authority. And therefore, the board adopting a rule when the declaration is silent, that would deem to be an improper rule outside of the board rulemaking authority. Okay. We got a very specific question about the good cause reasons that turn someone down, and got a very specific question about someone fleeing a war-torn country and wanting to buy or rent within your community. I respectfully, that's way too fact specific. There's a whole host of issues that arise from that, and I would kindly direct that person to get with your association's counsel on that. We got a housing for older persons question. This is a little bit outside of this course, but I had mentioned, in order to maintain the housing for older person status, you need at least 80% of the homes or units to be occupied by someone 55 or over. People sometimes call it the 80-20 rule, because obviously if you have 80% that have someone 55 or over, you may have 20% that's not. That does not mean that the board has to utilize that 20% amount. That 20% amount really should be used for extenuating facts. Let's say, unfortunately, someone 55 or older passed away, and their will, they left it to their son who's 48, something along those lines. I do not think that 20% needs to be used to allow minors. But again, these are very fact specific things, and you need to get with your association's counsel on it. We got a question about, if someone has a felony conviction, can we deny them? And my answer is, as long as your declaration has the underlying approval authority, in my opinion, a felony conviction can be used as a basis to turn someone down. Remember, you need to look at how long ago it was. Was it 25 years ago and that person's lived an outstanding life since? You may want to think about that. Okay. We got asked a question: if an association is charging a transfer fee where they're not allowed to do so, meaning their governing documents don't provide that authority, do you have to refund the fee? Well, it depends. Do you want to potentially be sued? If the answer is no, then my answer would be you might want to consider stop refunding or stop collecting those fees. And if someone makes a demand to return that fee, you might want to think about returning that fee that was not properly collected. All right, I'm looking. Give me just 1 second. I'm taking questions. Okay. I got asked, and I always joke, I always wait. There's always a time where someone asks an emotional support animal question. We teach a whole course on emotional support animals, but I do think it is a good question, which is someone wants to buy, let's say the community prohibits dogs. Someone submits a request for an emotional support animal, but they may not have the proper documentation from their healthcare provider. Our suggestion in those situations is to send something in writing to the applicant that says, we cannot process your application until you supply the proper emotional support animal documentation, and your application will not be approved until and unless we receive that. Okay. All right.
That's not a question. It's more of a statement, John. Andrew.
Yep, I see it. All right. So let me take a look. I'm trying to do my very best. I know I value everyone's time. So I don't want to, and I see some questions were in the chat, but it looks like they were also moved to the Q&A. So I appreciate that. Again, lots of the questions, if I didn't address them specifically, please do not take offense to that. They're just very fact-specific things that it would be outside of my certainly awareness of what your particular governing documents say. And also, it's just too much of direct legal advice to you. With that, Robert, I have 158. I'm not seeing any other questions. I got one last question regarding a children under 13, and can we deny them in a housing for older persons? Again, that's a very fact-specific thing. Certainly, if you're a housing for older persons community and you follow everything properly, you don't have to allow minors at all. I mean, minors under 18 can be restricted. Okay. All right.
Well, Andrew, I'd like to thank you for providing your time and expertise to Vesta and all the board members and all of those in attendance. I'm sure everybody, based on the questions, realizes that this is very valuable information. I'd like to thank everybody who attended and hope that you got some good insight on this webinar. And if there were any questions that were not answered, or if you have any questions that come up on the screen right now and on the screen during the past questions were the last slide, which has emails for both Andrew and myself. Please feel free to reach out to either one of us. Thank you again, everybody, for everything. And thank you again, Andrew, for your time.
Great. Thank you all very, very much. Have an awesome week.